What follows here is my opinion based upon what I have seen, read, heard, and experienced. None of what follows here is intended to advise anyone according to their specific legal concerns. If you need legal help, please find an attorney, but please be careful, or you may end up with estate planning documents that authorize previously prevented conflicts of interest. The law has changed. Fiduciaries can now be exonerated from self-dealing when certain authorizations are in place. Professionals connected to the financial services industry seem prone to seek those authorizations avidly and to want them very badly. Hey, money's involved. Deception, misrepresentation, lack of disclosure, and the manipulation of elderly, uninformed clients. Those things are possible. So what is a conflict of interest when it comes to the management of a financial account? Consider the traditional fee arrangement. Here, the fiduciary takes a small percentage, say 0.5% or so, of the account value each year as their annual compensation. If the account grows, they collect more fee dollars. If the account decreases in value, they collect fewer fee dollars. In this way, everyone's interests coincide and there is no conflict of interest. But consider what happens when an account manager engages in self-dealing, buying products from himself or his own institution. Then commissions and internal fees called fund level fees can then become part of the picture. It's possible for an account manager to make a tremendous commission that is far greater than any proper management fee, or for the institution to collect extra compensation above and beyond the traditional fee schedule. For centuries, rules were in place that prevented conflicts of interest. Now things are different. The change in the law is apparently due to the efforts of bank lobbyists, apparently the same bank lobbyists that got Bill Clinton to repeal Glass-Steagall, which set the path for the taxpayer bailout of extremely wealthy private bankers for their failed private business enterprise. Whether it's the fraudulent creation of new accounts, foreclosure fraud on homes, taxpayer bailouts, or conflicts of interest, the transfer of wealth from the American public to America's privately held central banking system is a concern for nearly everyone, except perhaps a subpopulation of individuals who are in league with the system. Unfortunately, a significant number of those individuals appear to be political leaders who hold public office. Wells Fargo was recently investigated by the Senate Banking Committee. New accounts were created fraudulently, signatures were forged. Sounds criminal, doesn't it? Yet no criminal prosecutions occurred. Look into things and you'll discover that the majority of the senators on the committee that investigated Wells Fargo received donations from Wells Fargo. There is an excellent opportunity here in this golden age of information for the American public to wake up and to pay attention to who it is that is funding their elected officials. My name is Ben Martin. I want to thank you for watching this video. My siblings and I have a remainder interest in a financial account established by our father's last will and testament. A number of abuses have occurred. A current concern is a false financial statement involving an executive currently employed by Wells Fargo. False reporting is a crime. Evidence of false reporting has been submitted to Melissa Nelson, the state attorney for Florida's 4th Judicial District. Let's hope she takes appropriate action. It seems pretty obvious that unchecked white-collar criminal activity will just lead to more white-collar criminal activity. Thank you.